There's a moment that went down inside the Supreme Court that almost nobody saw coming, and if you didn't witness it, you'd think it was fan fiction. Picture the highest court in the country, a place where people speak like they're trespassing in a museum, and suddenly the room goes silent because someone challenged Clarence Thomas to his face and didn't flinch. And before I tell you what she said, understand this wasn't a hallway exchange or a side hearing. This happened in the actual marble chambers of the United States Supreme Court. Reporters packed in, cameras on standby, clerks frozen like exhaling too loud might get them fired. And standing there, not a tenured law professor, not a polished appellate attorney, but Congresswoman Jasmine Crockett. Yes, that Jasmine Crockett, Texas, former civil rights attorney. The last person some of those justices expected to see take their mic. Across from her, Clarence Thomas, not in silent mode, not in the background. He looked ready, like he came preloaded with a dismissal before she even spoke. The second she started, he leaned in with that slow, condescending confidence and dropped a line you could feel hit the walls. He told her he'd read her brief 3 times, and said her understanding of constitutional law was elementary at best. Now pause. Imagine saying that in a packed Supreme Court chamber, on camera, to a black woman who's argued voting rights cases longer than some staffers have been alive. He wasn't questioning her argument. He was trying to shrink her. But she didn't shrink. She didn't swallow hard. She didn't stutter or even blink. She tightened her grip on her folder, looked him dead in the eye, and said, calm as a surgeon, "Justice Thomas, I appreciate your concern for my legal education. But in the next 5 minutes, I'm going to demonstrate exactly why your assessment is not only wrong, but dangerously misleading to the American people." That's when the oxygen left the room. She wasn't flustered. She wasn't rattled. She spoke like someone who already knew how the next 5 moves would play out. She opened the folder, and she didn't pull out talking points. She pulled out ammunition. She laid out the constitutional basis without academic fluff. 14th Amendment, 15th Amendment, the impact of the Georgia law, not in theory, in receipts. One of the conservative justices tried the classic clarification derail. Where in the Constitution is the right to vote without ID? She didn't even look down. She said, respectfully, that's not the question before the court. The Constitution doesn't list every method of access word for word for it to be unconstitutional. The issue is whether the process obstructs access in a way that violates equal protection, and the data on page 34 proves that. Normally, that's where the tension drops, but Thomas wasn't finished. He cut back in and said, data can be manipulated. What can't be manipulated is the text of the Constitution, and threw in another jab about elementary distinctions. And that's when the tone started to change. Not loud, not chaotic, but tight. One of those moments where even the breathing shifts. Instead of reacting, she pivoted. She cited precedent, his precedent. She referenced cases where outcomes, not intent, defined constitutional harm. Shelby, Gingles, opinions he'd touched himself. That's not a rebuttal. That's holding up a mirror. From there, she went further. She moved from precedent to the court's own blind spots. She said when courts set standards so narrow they erase harm by design, that's not neutrality. That's selective blindness. Reporters started typing like rain on glass. Then she turned directly toward Thomas, not theatrically, just enough to make it unmistakable. She said, "You referenced constitutional text. I'm referencing constitutional impact. When jurisprudence repeatedly narrows access and then dismisses consequences as anecdotal, the Constitution isn't being defended. It's being weaponized against the very people it was amended to protect." Silence. The kind you can feel. Then came the line that stuck the landing. She cited Shelby County v. Holder. Said the court dismantled protections under the assumption discrimination was over, and then pointed out that within 2 years, 868 polling places shut down in black districts. And then she twisted the knife. You dissented in Shelby, Justice Thomas. You warned this would happen. So the question isn't whether you saw it coming. The question is, why is the court ignoring that you did? That's when he shifted in his chair. And if you've watched him long enough, you know, that's thunder in Thomas language. One of the liberal justices cut in and asked if she was arguing the court created the very conditions it now refuses to fix. She said, "Constitutional harm doesn't disappear just because the court gets uncomfortable acknowledging its role in it." Even the conservatives glanced at Thomas like, "Are you taking this one or no?" And when he tried to claim she was assigning intent, she ended it with, "Interpretation without accountability becomes policy. And when policy erases protection, the Constitution isn't being interpreted, it's being abandoned." The camera's auto-focused. He didn't interrupt. He didn't rebut. For a moment, he didn't speak at all. And if you think that was the peak, you're wrong, because what she said next took aim at the legitimacy of selective constitutionalism itself. If you want the final blow, the line that made conservative analysts admit she cornered him, drop "finish it" in the comments, or just say the word. And before you bounce, hit like, hit subscribe, and send this to someone who still thinks congressional reps can't walk into the Supreme Court and change the temperature of the room.